Good afternoon, everyone. Thank you for being here today for this panel entitled Reparations and Restitution, the Role of the International Legal Community. My name is Tamara Voskanian. I have the pleasure of introducing our speakers today, these four remarkable women. Our first speaker is to my left, Maria Gevorgyan. Maria is currently a law student at the Russian Armenian University, and she worked with CFTJ for a semester conducting interviews with victims of the war. She has written about the legal status of private security companies in armed conflicts. Her current research focuses on autonomous weapon systems, such as drones, used in armed conflicts. Our second speaker, Sheila Paylan, is an expert in international law, human rights, and gender, based here in Yerevan. She has more than 15 years of experience working for the United Nations as an advisor on matters of international criminal, humanitarian, and human rights law, as well as conflict-related sexual and gender-based violence. Sheila spent most of her career advising the judges and senior officials of various UN-backed international criminal tribunals around the world, such as for Rwanda, Cambodia, and the former Yugoslavia. She was also appointed by the UN Office of the High Commissioner for Human Rights as the legal advisor and SGBV expert on the team of international experts on the situation in the Kasai in the Democratic Republic of Congo. She now regularly consults for a variety of international organizations, such as the UN and the OSCE, as well as non-governmental organizations, think tanks, and governments, including the Republic of Armenia, in its cases before the International Court of Justice, and she has published extensively on the subjects of atrocity crimes, remedial secession, and the responsibility to protect. Our third speaker is Talin Hitik. Talin is the principal at the law office of Talin Hitik, an award-winning boutique law firm in Chicago, specializing in conflicts of law and transnational dispute resolution. She's the founder and executive director of the Armenia Center for Dispute Resolution, an NGO dedicated to building capacity in alternative dispute resolution and establishing an arbitration center here in Armenia. Talin is also an academic associate in public international law at the University of Michigan Law School. Previously, Talin worked at the Hague Conference on Private International Law and at the Permanent Court of Arbitration. She was a lecturer of international humanitarian law and international human rights law at American University of Armenia and Yerevan State University. She also served as an international law expert to the Armenian Ministry of Justice, European Court of Human Rights Division. Finally, our fourth speaker is Siranush Sahakyan. Siranush is an Armenian attorney with over 15 years of experience in human rights law, judicial reform, and corruption prevention. She has served as an ad hoc judge of the European Court of Human Rights, worked at Armenia's Ministry of Justice, and as an aide for President Sahakyan. She's a founder and president of the NGO Protection of Rights Without Borders, and a co-founder of the NGO Path of Law, as well as the president of the International and Comparative Law Center of Armenia. Siranush serves as an expert for OSCE and ODIHR, as well as UNICEF Armenia, UNDP, and multiple local non-governmental organizations. She has worked closely with Armenia's Justice Academy and the School of Advocates, implementing judicial training programs for Armenia's judges and prosecutors. She also helped prepare curricula on the topics of constitutional law, human rights, integrity, conflict of interest, and public administration principles. Welcome and thank you to our speakers for being here. And let's get started. Maria, you have the floor.
Can you hear me? Oh, perfect. So today I will talk about the incendiary weapons, the necessary suffering they cause, and the role of international law regulating these terrible weapons. So I want to start with the words of a young soldier whom CFTJ interviewed right after the Artsakh war. I'm not mentioning his name to preserve privacy, but he was bedridden and severely injured when we visited him at National Burn Center. And despite the treatment, there was not much progress. During the interview, he told us, "I don't feel angry about anything or anyone because of what happened to me, because this is war. but I want the world to ban and condemn the use of these munitions. So today I want us to understand what these young soldiers' words really mean. So as you know, one type of incendiary weapons has been frequently used in modern warfare is white phosphorus. White phosphorus munitions often inflict second and third degree partial and full thickness burns and also cause severe eye irritation, paralysis, convulsions, and fatal cardiac arrhythmias. And often you can see smoke coming from the wound. It's because white phosphorus continues to burn. So the mother of one of the wounded soldiers that we interviewed indicated that her son developed left side paralysis. He lost everything that we, masked people, take for granted. The ability to move, eat food, and, other basic activities of daily living. But the most terrifying thing that he lost is the will of living. He told his mother that no one would love him. No one would love the disabled person like him. So the testimony we collected showed that the injured were fighting in an agony, and their parents were also deeply traumatized. The mother of one of the injured soldiers said, "I drove the car to the hospital, and I hoped that it would not be my son. At first, I didn't recognize him, and then I could not be in the hospital, seeing him in an unconscious state." Burns from the incendiary weapons also can social isolation. And these kind of things are silent issues that people don't always know about or don't want to talk about, but we need to talk about them as well. Mental health problems associated with burns injuries include, but are not limited to, anxiety, depression, PTSD, discouragement, helplessness, loneliness, and as well as suicidal ideations. So lastly, survivors and their families may experience economic consequences. Many burn victims are unable to return to their old job or cannot find a new one. If incendiary weapons cause injuries that are so severe, that cause so much unprecedented suffering, the question is, does the international law ban them? And the answer is, CCW Protocol 3 is the only international document dedicated to regulation of incendiary weapons. Nevertheless, the protocol contains two legal loopholes that reduce its effectiveness. First, the definition in Article 1 of Protocol 3 does not encompass munitions like those containing white phosphorus because they carry alternative functions of creating smokescreen, signal traps, legitimizing white phosphorus. And the second, the protocol has weaker restriction on ground-based weapons than airborne ones. This protocol draws an outdated distinction between airdrop and ground-launched weapons. This loophole ignores that incendiary weapons cause significant human suffering regardless of their delivery mechanism. Aside from the loopholes, I would note that CCW Protocol 3 only protects civilians from the effects of incendiary weapons. However, the testimonies that we collected made it clear that these weapons cause suffering that is so severe that the use of such weapons violates the principle of proportionality that is the cornerstone of international humanitarian law. And such suffering is necessary for civilians and combatants alike. So we need to tell people about human losses. We won't change anything until we focus on the fact there is terrible unnecessary suffering being caused by incendiary weapons. This suffering should be the primary factor shaping legal norms regulating the use of incendiary weapons. Thank you.
Thank you, Maria, and thank you for the work that you did with the Center for Truth and Justice to interview victims. It was very helpful hearing about that. For the remainder of the speakers, you each have 20 minutes, and if needed, I'll give you reminders at the 10, 5, and 1 minute mark. Sheila, please take it away.
Thank you, Tamara, for the kind introduction. A big thanks to the Center for Truth and Justice for inviting me to speak to you all here today. And thanks also to Maria for sharing with us the experiences of victims of incendiary weapons and the harrowing suffering they cause. I found in preparing for this talk to speak on this topic that I realized how difficult it was, not only because it's too broad to be able to fully address in such a short period of time, but also given how sensitive the subject is, especially for victims of atrocities and their families, of whom there are likely some, if not many, in this room now or watching today. Because, of course, the urgent need and the innately deep desire for reparations and restitution in the immediate aftermath of armed conflict and gross human rights violations are, on the one hand, deeply universally felt as a matter of natural justice, but at the same time, in reality, are just too rarely implemented. Victims of ordinary crimes are still more likely to receive redress than those who have suffered really major gross human rights violations, especially when there are many victims and when it's in the context of an armed conflict. Most victims of such serious violations continue to suffer stigma, social exclusion, and re-victimization as a consequence of the lack of reparations and assistance in order to overcome the impact of armed conflict. And among the victims, most affected are women, children, and victims of torture and sexual violence. For a majority of these victims, the absence of reparations impedes their ability to resume their lives and move beyond the trauma that they have endured. One explanation for why the right to a remedy has yet to be adequately transformed into practice is that the field of international criminal justice is still relatively quite young, which I like to think means I'm also still kind of young, but anyway. It's only since the 1990s, so just some 30 years really, that the global community has directed considerable efforts through the establishment of international tribunals to prevent and punish the most serious international crimes. But these efforts have focused almost exclusively on criminal prosecutions. So in other words, they focus on the perpetrator. They focus on pursuing and punishing perpetrators, mainly as a form of retribution and deterrence. This almost exclusive focus on chasing the bad guys has been at the expense of helping the people the bad guys hurt, the needs of the victim for whom criminal prosecutions may really not be a priority. I saw this firsthand throughout my career working at, these various UN-backed international criminal tribunals, how sometimes this focus can have an almost perverse effect of relegating a victim to the role of a witness, nothing else, thereby just seeking their testimony, taking it from them. And then they have to go home still devastated by loss of limb or property or dignity, living in total poverty, while the perpetrators receive really good food and medical treatment at the expense of the UN in a UN-funded prison, even being treated, say, for HIV/AIDS that they may have passed on to their victim, who then has no access to these sorts of facilities when they have to go home having participated in a trial. There's therefore now, an emerging recognition that a more sustainable justice requires a tripartite balance. So it can't just be about holding perpetrators to account. It doesn't end there. But we have to also seek the truth and provide reparations. This added need for truth and reparations in its practical implementation has only really begun to seriously develop and come to the fore probably just over a decade ago. I emphasize here the practical implementation part because a victim's right to a remedy, right to an effective remedy, has been well enshrined, well codified in almost every human rights and humanitarian law treaty or convention since the early 20th century. But it wasn't until the end of 2005 that the international community recognized the need to go beyond just paying lip service to these legal obligations, which weren't being respected, and identify ways to implement them, as a result of which the UN Commission on Human Rights, which now we call the Human Rights Council, adopted the UN Basic Principles and Guidelines on, it's a really long title, the UN Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross Violations of International Human Rights Law and Serious Violations of Humanitarian Law. If you open the webpage for that, it takes a whole screen. Yeah. So I'll just call them UN Principles from now on. Then in March 2006, the UN principles were adopted by the United Nations General Assembly in its resolution 6147, thus further strengthening their status, even though UNGA resolutions are not formally binding. The UN principles detail 5 components or 5 elements of which comprise the right to reparations. The first is restitution, which is basically returning a victim back to his or her original situation or state before the crime or violation occurred. The second is compensation, which is just payment for an economically measurable damage like the loss of property. The third is rehabilitation, which is just like medical, psychological, social assistance. This element is actually, it's been studied, is one of the most neglected element of reparations for victims. The fourth is satisfaction or just satisfaction, which can be anything. It's basically a broad range of measures like an apology or an official declaration by a court of law. Sometimes just the fact that a violation has been found to occur can be reparation enough in the idea of the court. Not necessarily my opinion, but, or like commemorations and statues and tributes and stuff. And the fourth, which is really important, is the guarantee of non-repetition or guarantees of non-recurrence, which are also a broad range of measures that can be taken situationally specific to, but just aimed at contributing to prevention, like, you know, strengthening the judiciary, the independence or the judiciary, or enhancing legislation and the such. Whether one or more or a combination of these elements, which of them will be most essential to victims of violations, especially after armed conflict, will of course need to be carefully identified and will depend on the circumstances. So for instance, a victim of torture is not usually interested in like monetary compensation because that's not what was taken away from him or her. They were going to need to come up with a way to restore their dignity and humanity. That's what they lost in the process, and money just doesn't, there's no price you can put on that. At the same time, I'm sure every Armenian can relate that while an acknowledgement of a state responsible for an injustice is, you know, obviously important, it may not be enough if it doesn't come accompanied by, say, guarantees of non-repetition. You know, why do I want your apology if I have no idea if you're going to do that again? And then, so for that reason, a victim-centered, victim-oriented approach is really crucial in fulfilling this right to remedy and actually repairing and restoring a victim, rather than any standard cookie-cutter approach. So even though reparations to victims are clearly a state responsibility, the international community, I'm trying to stay on topic here, most notably the UN, plays a considerable role in promoting and implementing this right. For instance, through the establishment of UN-backed transitional justice mechanisms, truth commissions, and trust funds. Transitional justice calls for a careful timing and thoughtful sequencing of truth-seeking initiatives, reparations, institutional reforms, and individual accountability measures. So as I said, remedies such as reparations and revealing the truth are really often more important and more urgent to many victims of human rights violations or conflict-related crimes than criminal prosecution or trial. Truth commissions have made particularly important contributions to the rights of victims to receive reparations, especially when compared to initiatives such as the ad hoc tribunals. Clear and explicit references to reparations for victims can be found in UN-mediated peace agreements, for example, for Guatemala and Sierra Leone. In both countries, the establishment of UN-supported truth commissions were directly linked to the peace agreements. In the case of Sierra Leone, the peace agreement specifically referred to the setting up of a special fund for war victims. And, similarly in East Timor, Truth Commission was established also during the UN administration. The mandates of these truth commissions had in common that they clearly aimed at providing a comprehensive analysis of violations during the armed conflict, their impact on victims, and also authorized the commissions to provide recommendations regarding what reparations would be suitable for victims. To what extent these truth commissions really contributed to the advancement of reparations claims is yet to be fully appreciated because it's still so new. But case studies do show, obviously, a progressive state practice, and the impact of the growing number of truth commissions across the world indicates that they have played and that they will continue to play a significant role in promoting the practical implementation of the right to reparation for victims of armed conflict. Am I good on time? Okay. Well, depends how much I have left, right? Okay. Another example of the practical role that the UN has played is the UN Compensation Commission, or the UNCC, which the UN Security Council created in 1991 to process claims and pay compensation for losses and damage suffered as a direct result of Iraq's invasion and occupation of Kuwait, which started the Gulf War. This set a unique precedent as it was the first mechanism created by the UN whereby individual victims could claim compensation for violations in armed conflict. However, the unprecedented operational modalities of the UNCC have not been repeated in other instances. The Security Council has failed to endorse any other subsequent such initiative, such as, for example, the recommendation for a similar compensation commission in Darfur. So in this way, the international right to reparations is not fulfilled if it's not applied or implemented across the board for all victims of violations. One look at the current global outcry for Ukraine, for instance, which, although perhaps certainly justified, is enough to cause dismay in other contemporaneous victims of similar atrocity crimes around the world, whose plights have been or are being overlooked or ignored. The international legal, not just the international legal community, the international community has an important moral obligation to ensure that it does not dole out selective justice. Anything less could suggest that some victims are more deserving than others of redress, which is of course not true and only serves to exacerbate a victim's trauma. I could go on, but I'm conscious now of time, and I am as anxious as I'm sure you all are to hear from my distinguished co-panelists. But I'll just wrap up by emphasizing that the effective practical implementation of the right to reparation at the global level remains a principal challenge. So as much as we want to see this change happen now, it's going to take some time. Progress has been made, but more is needed, and will depend on the vigilant scrutiny of the obligations of states and on the degree of solidarity of the international community in order to prove that victims of the most serious violations, irrespective of where they are in the world, are no longer just an afterthought, and that their rights are not only ensured by law, but also in practice. So on this note, I'll end by reading the beginning, or the preamble. Preambles are the best, of the UN principles, a part of it actually, which reminds us of the path forward. In honoring the victim's right to benefit from remedies and reparation, the international community keeps faith with the plight of victims, survivors, and future human generations, and reaffirms the international principles of accountability, justice, and the rule of law. That's it for me. Thank you.
Thank you, Sheila. We'll add those few extra minutes into the question and answer time, which I'm sure everyone will appreciate. And on that note, everyone, if you have questions, you can raise your hand and someone will bring you a piece of paper. And then you can raise your hand again. They'll come and bring it to me so that we can do the questions at the end. I wanted to also mention quickly that the monitors in the hallway between this room and the Manugyan Hall, those are showing, I don't know if you saw the screens, but they're showing testimonies that CFTJ has taken with witnesses from the war, and they're transcribed into English, so you can look at those, please, during your walk between the rooms. And one more thing, panelists, I'll just give you the 5 and 1 minute sign just to eliminate any confusion. Let's go to our next speaker. Talin, you have the floor.
Thank you so much. Can everyone hear me? First of all, I just want to extend really a heartfelt thank you to CFTJ, not only for inviting me to speak, and as Sheila said, on this really distinguished panel. I'm so excited that we have an all-female panel of powerful women. Not a manel. Yeah, round of applause. Round of applause for women pushing forward human rights, right? But on that note, also to CFTJ, as Judge Abkaryan mentioned yesterday, is like 98% women as well. And I just want to congratulate you on the success so far of this inaugural conference. And we're all really looking forward to your continued efforts. So thank you for inviting me, and also thank you for your work. I'm going to narrow in a little bit. I don't know why, but I decided to be the practical and prosaic person because I have 2 human rights concentrated people, and I'm the dispute resolution person nowadays. Yeah, so I'm in the middle, sandwiched by these eminent human rights scholars. But so I'm going to narrow in on restitution of property rights and property claims in the aftermath of armed conflicts through the mechanism called international claims commissions. So we have a history of these claims commissions. It's a little reparations, as I'll explain later. Reparations is the broad term, and under reparations we have restitution as one of those reparation mechanisms. So I will touch upon the origin of these mechanisms, their evolution, especially in the second half of the 20th century after World War II. I'll also touch upon their legal framework and some key procedural differences between these mechanisms. My hope is to outline the different options that could benefit those concerned with the planning, negotiation, or design of any future claims program. On that note, I just want to take a step back and remind everyone here that all of the options we're talking about today are a few of many different avenues for seeking some sort of remedy or redress. We heard earlier today about avenues in domestic courts using universal jurisdiction, most notably in Germany and in the United States. So I won't touch on the avenues in domestic courts. And I think tomorrow there's another session that sort of touches upon civil claims. So when we're thinking about all of these different pieces and everything you'll hear in the conference from yesterday, today, and tomorrow, we have to just remind ourselves to think about what our goal is and work backwards to find the right remedy. We should not be taking a piecemeal and ad hoc approach where we, in the diaspora and in the Republic of Armenia are saying, well, we have this small avenue, so let's go forward and see how that goes. Then we have this small avenue, let's go forward and see how that goes. It should be a coordinated effort, and it should, at the end of the day, focus on the rights of the victims, as Sheila put so well, and figuring out how to make ourselves whole again. And then we work backwards and find the right remedy. So today we're discussing some of those remedies under the framework of reparations, but we should consider all of the things we're hearing in this conference as a whole and try to figure out how to move forward. Okay? So, claims commissions that provide for restitution of land and property rights, compensation, or other remedies to victims of gross human rights violations or serious violations of international humanitarian law play an ever-increasing role in reconciliation and rebuilding measures following a conflict or a crisis. They're important rehabilitation tools for countries in transition, and they reduce the risk of a country, or in this case, countries, relapsing into a conflict later on down the road. The complexity of resolving many thousands of claims in a short period of time under high political pressure, which is always the case, there's always going to be high political pressure in these cases, and with limited financial resources available, requires careful early consideration of all of these different possibilities and challenges for the implementation of a fair and effective process that will get the desired results. So, since we're lawyers, let's start with some legal definitions. I think, to my mind, the most clear definition that lays out what I was describing earlier as the interplay between reparations and restitution comes from Artsakh, which is a really weird acronym, which stands for the Articles on State Responsibility for Internationally Wrongful Acts, which was adopted by the United Nations. And Article 34 of Artsakh deals with forms of reparation. Quote, full reparation for the injury caused by the internationally wrongful act shall take the form of restitution, compensation, and satisfaction, either singly or in combination, in accordance with the provisions of this chapter. So as I mentioned, we have the umbrella term reparations, under which we have some options, which are restitution, compensation, and satisfaction. And I think Siranush will touch a bit more on satisfaction. I'm concentrating here on restitution. Then we have Article 35, which actually defines restitution. A state responsible for an internationally wrongful act is under an obligation to make restitution, that is, to re-establish the situation which existed before the wrongful act was committed, provided and to the extent that that restitution, A, is not materially impossible, and B, does not involve a burden out of all proportion to the benefit deriving from restitution instead of compensation. Okay, so that's a little bit of a mouthful, but basically what they're saying is to find and strike a balance in fairness. So if the restitution amount ends up disfavoring the party being asked to pay the restitution, then restitution is not the right remedy. Then we would go to compensation. What do we mean by compensation? You destroyed my house. It was worth, 100,000 euros. So we're going to give you back 100,000 euros. That's just traditional compensation. Restitution also includes, restitution includes, the physical damages as well as the moral damages. So that's sort of the difference. Also, the notion of restitution is, in this context, aimed at restoring the status quo ante by means of reparation in kind. So basically trying to get to a point to make the victims whole again to the extent that that's possible. And the restitution may be material or juridical, and both can be granted at the same time and in tandem. So now I'll just touch a little bit on the historical framework. Where do we even get these concepts from? In examining the historical legal framework of restitution, we should not look for fixed points in time, but rather sort of a continuum of time between the past and the potential future evolution of this right to restitution. Excuse me. The right of reparations generally has two dynamic aspects. One is its expansion from traditionally a right of the state to become an individual right. The other is the shift from interstate resolutions, interstate meaning one country versus another country, resolutions of reparation claims, such as the conclusion of a lump sum agreement. Lump sum agreements were very common in the aftermath of World War II. Germany decided to make many series of lump sum agreements. Lump sum agreements for compensation, essentially, towards victim-oriented mechanisms entitling individuals to claim reparation for harms that they have suffered. The victim-oriented right to reparation has been developing over the last 30 years in tandem with the establishment of these ad hoc restitution mechanisms. These bodies manifest the intentions of policymakers involved in the creation of the restitution mechanisms and in the drafting of the respective constituent instruments. Whether the policymakers are a third-party intermediary or just legal experts working at the UN Secretariat, from a certain point on, they started to establish these restitution mechanisms that aimed at resolving the claims of individual victims rather than to disregard these claims entirely or to resolve them only through the lump sum settlements, which, as Sheila mentioned, was sort of in the mid-1980s to 1990s is when we moved from just lump sum settlements or just a state versus state settlement to a victims' rights approach. So this concept was recognized all the way back in customary international humanitarian law, and probably most notably codified for the first time in 1907. Earlier today, we had another mention of the Hague Convention respecting the laws and customs of war on land. In Article 3 of that convention, right at the very beginning, it establishes, quote, a belligerent party which violates the provisions of the said regulations shall, if the case demands, be liable to pay compensation. It shall be responsible for all acts committed by persons forming part of its armed forces. We also, from that point on, we also have the Treaty of Versailles in 1919, which Armenians, I think, are very familiar with the Treaty of Versailles for obvious reasons. And Article 231 is usually called the War Guilt Clause. It's the most main operative clause of the Treaty of Versailles. And basically it says the Allied and associated governments affirm and Germany accepts the responsibility of Germany and her allies for causing all the loss and damage to which the Allied and associated governments and their nationals have been subjected as a consequence of the war imposed upon them by the aggression of Germany and her allies. And based on the responsibility that Germany admits to in 231, Article 232 then continues. It obliges Germany to, quote, make compensation for all damage done to the civilian population of the Allied and associated powers and to their property. Okay, so this is how this evolution has gone through time. And then we sort of skip forward to the parts that Sheila mentioned, so I'll skip over those. But the UN basic principles are important to note on this timeline, on this evolution. So what is a claims commission anyway? Basically, it's a flexible tool that's a juridical or quasi-juridical tribunal or mechanism that can resolve mass claims arising out of an international crisis. The Commission's authority is usually set up by an international agreement by the parties, And that international agreement is usually brokered by a neutral third party or like another state that's interested in the resolution of this dispute, or by the United Nations itself. Sometimes even international organizations or civil society organizations will be parties to will be at the negotiating table as well. It can hear cases of individual claims as well as cases of collective claims. Why would we use this model? Why is this one of the models we should use, a claims commission, as opposed to domestic civil court or using universal jurisdiction to obtain jurisdiction over individual defendants? Well, a claims commission has some really good benefits that the other mechanisms don't have. First of all, it's the most flexible proceeding. So imagine you can have the seat of the commission be in Yerevan. You can have the seat of the commission be in Paris. You can have the languages of the commission be Armenian, English, German, Russian, French, I mean, you name it. The language of the proceeding is up to the parties. The rules of the proceeding are up to the parties. And a really practical procedural note is that the timeline, basically the deadline on claims, is usually very short. And that's a benefit to the parties, right? So we're going to open up the floodgates. Everyone bring your individual claims. Was your house destroyed? Did you lose relatives? But only for 1 year, for example. The deadline is 1 year, and then those individual claims will stop, and then all of them will be processed and adjudicated. Oftentimes, there's no appeals process, and this is in the spirit of efficiency, essentially. Am I at 5 yet? Okay, thanks. There's basically no other mechanism to adjudicate a massive amount of high-value claims. For example, the United Nations Compensation Commission adjudicated millions of claims on behalf of the victims, and it was really an impressive feat. As Sheila mentioned, that massive amount of claim adjudication has not been repeated, and the UN Secretariat has not taken on a claims commission in the same way since they did it for the Iraq and Kuwait situation. Third-party assistance is always really beneficial. So you can use other international organizations and other parties to assist and help facilitate not only the negotiations, but the claims process itself. For example, in the Iran-US Claims Tribunal, which was obviously negotiated between Iran and the United States, the lead negotiator from the United States State Department noted that the Algerian government played such an indispensable role and credited the foreign minister of Algeria for helping to resolve every single problem that we ever confronted. These tribunals often may choose to grant individuals direct and immediate access to file their own claims without a state having to act on their behalf. So again, the traditional notion was a state versus state claim. That was sort of the pre-World War II option. And now we have these flexible proceedings where both individual citizens can come forward and bring their claims, and then other governments can also come forward and bring their claims. So it has jurisdiction over everyone in the conflict, which makes it really helpful. What are some potential difficulties with this model? Well, I'm sorry to tell you, but there's no enforcement mechanism. So this isn't an international court. They don't have courts martial. There's no subpoena power to gather evidence. Basically, this is the biggest hurdle. The most prime example of this is the Ethiopia-Eritrea Claims Commission, which did really great work, was negotiated between the parties. It was brokered by the UN and other third parties. It was run by the Permanent Court of Arbitration, my former employer. And they went through thousands and thousands of claims, and they determined fault for the conflict, some fault on Ethiopia's side, some fault on Eritrea's side. And then they awarded damages to both sides, actually, in upwards of over $200 million to each side. To this day, not a single dollar of that money has been paid because there's no enforcement mechanism, and that tribunal did not set itself up to have basically a pot of money. So the enforcement mechanism was completely lost in that case. We have more successful models like the Iran-U.S. Claims Tribunal and the UN Compensation Commission, which basically collected their pot of money first before the cases even started. And in that sense, those damages were paid, and actually they're still in the process of being paid. These mechanisms, claims commissions, require a lot of support from the international community. For example, the United Nations Compensation Commission was actually set up by the UN Security Council resolution. As all of you very well know, that would be an impossibility in the situation between Armenia and Azerbaijan. And it would also be a marked impossibility in the situation between Ukraine and Russia, Russia having veto power and having already demonstrated its willingness to use its own veto power to block condemnation of its own conduct. So we're sort of at a political stalemate there. We can't use the UN Security Council, and we do need some sort of international support. So basically, another part is obviously, aside from the international will, they also take an enormous amount of political will on behalf of the parties. You have to be able to come to the negotiating table willing to hold the other side accountable, and also willing to be able to hold yourself accountable. The claims will come. There's no such thing as a claims commission that only has claims. Let me put it this way. There's no such thing as a claims commission between two states where only one state is contemplated to have any liability at all. All individuals that were in the conflict and at the territory of the conflict should have the right as victims of that conflict to bring a claim. And therefore, the damages might be paid by either side. An important note, though, I'll note that earlier today in his remarks, Professor Tatoyan mentioned that there were Armenian businesses that invested $5 million in a region, and they made that investment because they were confident that the area where they were making the investment was the territory of Armenia, right? And nonetheless, they lost their investment in the conflict. That would be a perfect example of a great plaintiff or a great individual claimant in a claims commission. And in fact, that's the model that was used in the United Nations Compensation Commission. They had 3 buckets for individuals and 3 buckets for corporations and governments to claim, I lost my business, I need compensation, and they were paid fair compensation for their losses because of the armed conflict. I see that my time is up. So I will just very briefly conclude again by just simply saying thank you, and also encourage you again to just keep all of these pieces in mind and remember that we're trying to have a victim-oriented approach and make the victims whole again. So we have to take a comprehensive view of all of these mechanisms and decide the best way forward. Thank you.
Thank you so much, Talin. Siranush, please take it away.
Thank you. So it's also my great pleasure to be part of this distinguished panel. And I specifically thank to International Center for Truth and Justice for enabling this meaningful discussion on emergent issues of public general interest. So I'll try to put into Armenian context these international rules, regulations that are connected to reparation for victims for human rights violations. First, it's important to offer reparation when we speak about gross violations of international human rights law and also serious violations of international humanitarian law. In case of other violations of less important nature, this reparation is not as critical as in case of gross and serious violations we faced during the war. And international regulations also target to this specific situation, considering the nature of violations. So we have discussed the restitution, compensation, which is offered to victims in most cases. But in my opinion, we have other types of reparations which are critical for this specific context. So I would like to focus on right to remedy, right to investigation, and right to truth. Why? Because without ensuring impunity, will not achieve justice for victims. So this right of remedy is a part of right to reparation. So in the realm of inter-American system, also European system, it is mostly understood as right to judicial remedy. So we seek the involvement of judicial authorities to independently investigate and establish facts and offer reparation for the victims. But we don't exclude that in some cases, other non-judicial remedies can become operational, which is fully in line with international law. And within this right to remedy, states have an obligation to investigate human rights violations, not to deliberately skew investigations or not to conceal the facts. And within this obligation, they have the duty to communicate the truth to the families, showing all surrounding facts concerning human rights violation. So the denial is not permissible, and it also amounts to inhuman and degrading treatment towards the families. And at the initial stages, this right to truth was not explicitly recognized, but it was derived from the right not to be subjected to inhuman treatment. And refusal to provide true information about the happening for a prolonged period of time really amounts to inhuman and degrading treatment, if not to psychological torture. So if we turn to our situation, of course, we have these rules which oblige Azerbaijan to do investigation to clarify the facts, especially when they possess exclusively the information. So whatever happened is under their exclusive control, and other parties, Armenia or third parties, have limited access to information. So it is not realistic to expect a full and complete investigation from other side, because the information is concentrated on the hands of Azerbaijan. Unfortunately, we don't see the readiness of state to discharge its international obligation. And before international courts, they act in the angle of denialism. So they have the practice to deny the events despite strong evidence proving the contrary. So now we will watch two videos which were communicated to Azerbaijani government through a European court in the frame of individual applications, and then we'll see what type of steps were taken by Azerbaijan and how they respond to these incidents and how they bring truth to the families. Can we start watching the videos?
Karabakh.
Karabakh est Azerbaïdjan.
Karabakh.
Это Азербайджан.
Ты сам сказал. Карабах.
Это Азербайджан.
Ты сам сказал. Карабах, Азербайджан.
Карабах, Азербайджан.
And the second one?
Имя.
Artsakh.
Фамилия.
Karapetyan.
Карабах.
Азербайджан.
Карабах.
Азербайджан.
Честно?
Честно.
Ладно.
So these two videos are verified. We know the identities through identification of the victim. We know also the identities through the families. We know the area where this incident happens. We have many alive victims who escaped the incidents and were lucky enough not to be taken into captivity. We also have repatriated POWs from the same group who give us the details of the incident. And of course, these videos were provided as a proof showing that those two Armenian servicemen appeared in the hands of Azerbaijan under their control. They were captives, and currently they are enforced disappearance because officially Azerbaijan does not acknowledge their captivity and refuses to provide any information about their fates. In the European Court, Azerbaijani government provided a written reply. So if we open the file, we'll see this denialism. So first they show their efforts. Can we see the document also? So we saw that they show that some investigation took place in Azerbaijan. For example, those videos were communicated to relevant headquarters, departments, and military units of the Ministry of Defense of Azerbaijan. So these footages were shown to military personnel. However, no servicemen identified who were in the video, not from Armenian side, not from Azerbaijani side. So they took some witness statements, and at the end, they just said no possibility for identification, so no proof that those people are detained and are kept in Azerbaijan. And also they challenged that the dissemination had not been considered feasible. And we have a very copy-paste version for the second video footage. So they provided the same reply in respect of Arsen Karapetyan's footage and also Norik Arakelian. So these standard formulations are used to deny. These are illustrations how the state fails to investigate and provide the truth to the family. And in respect of this right to truth, the address is not only the family or relatives of disparate people, but also the society as a whole. And we have judicial opinion from European Court and also Inter-American Court. They confirm that the society also has a right to understand how the things happened, what was the reason for the conflict or these gross human rights violations, and by whom they were committed, and what steps are being taken in order to avoid repetition in future. So this is one instance when we see that this obligation theoretically exists, but practically we face many challenges. How we overcome when we bring these applications to the court, we also challenge dispute, the lack of effective investigation. And in many cases, the court found that state also violated right to life, freedom to be, the right to be free from torture, because of not investigating the facts. And with this judicial ruling, we are able to supervise the implementation at the local level through the engagement of Council of Europe bodies, for example, Committee of Ministers. So we engage international community to supervise the implementation of judgments and achieve domestic investigation of the cases, identification of the perpetrators. The second part concerns restitution, which is especially critical for right to property cases. I fully agree with Talin that these claim commissions are more efficient for us, for resolution compared to human rights courts. We have I would say bad practice from the European Court of Human Rights, which failed to provide adequate compensation, restitution of victims from right to property. You all have heard the cases, mirroring cases, Chiragov versus Armenia and Sahakyan versus Azerbaijan. So we have people who flee from their settlements during the First War. And around 30 years, they were left without home, without minimal living conditions. They lived in rental houses. They lost their community identity, and so on. So after many years, European Court delivered a judgment and acknowledged violations, which is, of course, a form of satisfaction. But the court supposedly offered compensation for the victims, and I want, to give the rationale of court reasoning for giving just only 5,000 euros compensation for pecuniary and non-pecuniary damage of those victims. Just to compare, the legal costs and expenses for restoring the rights through the court were 30,000 euros. And the court's reasoning was as follows, which is again frustrating. So the applicants are entitled to compensation for certain pecuniary losses and for non-pecuniary damage. The damage sustained does not lend itself to precise calculation. Further difficulties in the assessment derive from the passage of time. This consideration is particularly prominent in the present case concerning a continuing violation of the applicant's property rights, in which almost 10 years have already elapsed between the applicant's displacement from Gulistan and the entry into force of the convention, and some 15 years have elapsed thereafter. An award may still be made, notwithstanding the large number of imponderable involved. The level of just satisfaction to be awarded must be determined at the court's discretion, having regard to what it finds equitable. And then the court concludes that 5,000 euros will be awarded, covering all heads of damage, so pecuniary and non-pecuniary. So this example shows that the European Court of Human Rights is not the best fora to offer restitution of property rights. So we tested this system for the First War consequences, but for the 2020 war, we deliberately refrain from using this instance for right to property cases. So we mainly focused on war crimes, right to life violations, torture, and so on, but refrained from focusing on property rights at this instance. And I will briefly address satisfaction part. Why it's important? Because it provides compensation for moral damage, but not in the form of monetary reparation, which is very easy, but other forms of non-monetary reparation. So the best way to achieve compensation for moral damage would be satisfaction, and the most well-known forms are apology, public acknowledgement, acceptance of responsibility, and also search for truth and responsibility for the fault. This part has also a public commemoration, which would be very relevant in case of Armenian conflict. This public commemoration is not widely used by the European Court, but a wide practice is existent for Inter-American Court when, for example, streets were named on behalf of the victims. As Azerbaijan also tries to gain psychological superiority over Armenians, and this hatred is there, I think a public commemoration would be the adequate form of satisfaction for Armenian victims. So if we achieve, for example, in case of Gevorgyan Markaryan, to pressure on the Committee of Ministers to name a street on behalf of Gevorgyan Markaryan in Baku, this would really serve as a satisfaction of our moral damages. But these forms of satisfactions are left to the discretion of courts, and they refuse to name it, list them in the judgments, and the fora where we need to invest resources to achieve something is the political bodies like Committee of Ministers, where we need to work diplomatically to opt for the best and adequate measure of satisfaction. So my suggestion would be like to have also shift from legal proceedings to this political diplomatic proceedings. We already have a big number of judgments from international courts acknowledging, establishing violations. So now we need to achieve a reparation for our victims with a focus on satisfaction to compensate the moral damages on the national dignity of Armenians. Thank you.
Thank you, Siranush. I want to thank all the speakers here. Clearly, the audience is very interested in your topics. I've received more than 17 questions, and I'm sure there's more. I apologize, there's no way I can get to all of them, but I would want to encourage you, we'll do as many as we can in the time we have, and I want to encourage you, please approach the speakers after and talk to them, okay? I know they really want us to learn, so I'll just offer them. Okay, let's get started. For Sheila, you said that criminal prosecutions may not always be desired by victims, and they may even impose harm. In your experience with victims of the Artsakh war, what do most of them wish for?
I'm going to let the CFTJ or Siranush answer that, because I didn't have enough direct contact with the victims of the Artsakh war. I can tell you, for instance, you know, when I work directly with victims of sexual violence in Congo, and my main role was to try to get them to actually press charges against their perpetrators, because otherwise, you know, it is a very important part. But they were literally starving. I mean, they couldn't even, it's not that they didn't want to pursue their perpetrators, it's that they couldn't eat, and they had children to feed, and one was pregnant with the result of her rape. So my hands were tied, you know, as a UN staff member. There's nothing I can do. My job is limited to that one thing. And if she doesn't want to pursue perpetrators, my job stops there. You know, behind the scenes, of course, I would take her to an NGO and follow up and make sure that she would get the help that they needed. Of course, it's not always just women, but most of the time. So sometimes you just have to. We won't even get to a criminal prosecution. It could be more traumatic for a victim if we don't take care of certain fundamental parts first. Like, what do you need to be able to eat, go to sleep, not be scared, and then think about, something is that criminal prosecutions are no joke. I mean, that's really, really hard. And sometimes they don't lead anywhere. Sometimes, you know, a victim can think that they're going to have justice, and it doesn't always happen. And that can be extremely re-traumatizing as well. It's very delicate. So, people who work with these victims, I'm sure CFTJ, so you know, there's such an element of psychology and kindness involved. We can't be robots. So I would pass that specifically to Artsakh victims. I'm going to ask Siranush to answer that.
I think the only risk we have is the risk of retaliation for people who are still in Azerbaijan. So we cannot ensure their security, and if we raise prosecution issues connected to these people, for example, treatment, then they might retaliate, and those could be subjected to torture. So we can work in a safely environment when all known captives are returned to Armenia, and we secure their safety. Even for those who are already in Armenia, they fear from retaliation, because we all know that special services of Azerbaijan could access to Armenia directly or indirectly, and they can also threaten to captives and their families to meet with them in Armenia and retaliate. So these threats are real. They even voiced about them while working with prisoners of war. And I fully agree with Sheila. Sometimes we initiate proceedings, but there are also political factors affecting the process. So we don't have sufficient evidence on perpetrator. There are negative political considerations. We don't achieve justice, at least in a short term run. but we create a risk for those who are still in the hands of Azerbaijan.
Based on your experience working with the victims, would you feel comfortable identifying what you believe are to be what the victims of the Artsakh war want?
Yes, definitely. They all want justice, but through safe means and at the proper timing. So this time factor and additional guarantees are important, not to harm critical interest of victims and relatives.
Thank you. This question is also for you, Siranush. You mentioned that states have a duty to investigate violations of human rights, but how can states whose civilians are not permitted into the territory of Azerbaijan collect physical evidence other than from POWs, returned POWs?
When we speak about duty of investigation, we refer to responsible states. So it's primarily upon the violating state to investigate and accept responsibility for the happening. And if they fail to discharge this duty, then we have other instruments, through universal jurisdiction or with the help of international human rights bodies, which complement the domestic remedies. But first, we expect response from the state. If there is a failure, we add a new human rights violation, failure to investigate. And whenever there is no proper investigation, the burden of proof is different. So we benefit from their failure to investigate by changing the rules on burden of proof. So we shift this burden on the state to deny our allegations with reliable evidence. And if they fail to do so, our version becomes credible and established. So from tactical perspective, it is also important to raise this duty of Azerbaijan to investigate, then bring this issue before foreign law enforcement authorities or human rights tribunals.
Very interesting. Thank you. The next question is, can victims request sovereignty and the right to self-determination as a remedy or type of reparation? Talin, would you like to take this?
Yeah, I think unfortunately the answer is no. Self-determination is not a juridical solution to the acts of an armed conflict. Self-determination is a part and piece of sovereignty, which is more under the realm of international political identity. So it's under the political realm. It would not be appropriate. Also, just the basic principles of sovereignty is that a court cannot grant territory sovereignty. That there's no juridical solution to grant a territory sovereignty. That's not how the principles of sovereignty work.
Thank you.
Well, I will say it can work if Azerbaijan says okay. Like if they really want to separate it, because we've seen secessions, we've seen countries peacefully split. So if it is that they can't live side by side, or there can be a mutually agreed separation. Obviously, that's not going to happen, but it's not impossible. And then so I think because the question was, can the victims request it? They can. That doesn't mean they'll be granted.
As in, they could use the judicial process if they both agreed to.
Oh, no, sorry. It is a political act. There's no legal, there's an international legal right of self-determination, but that doesn't mean secession from a territory. That's not what it means. It means usually a right to determine oneself within a nation state's borders. That's the norm. The very rare exception is an external self-determination, and that is not a legal right. That's something that depends on the political will of the international community to recognize if the mother state doesn't agree to it to begin with. It's a complicated, yeah.
Yes, but this does not also mean that a judgment is void of any effects on political resolution of the conflict. So if we have a great number of judgments establishing human rights violations, reluctance from state to investigate, to punish, the policy of discrimination, no workable guarantees for avoidance of repetition, then those judgments should effect on political processes. So there is a possibility to capitalize these legal judgments during political processes to deny any suggestion which can imply putting people subjected to systemic human rights violations under the control of violating state. So no direct possibility, but they can be used for political purposes as well.
Thank you. Next question is, yesterday we were informed that an Armenian doctor from the USA was able to gather some evidence during the war about the use of white phosphorus, but is unable to find a lab able to confirm the results. In order to use such valuable evidence, what can Armenian lawyers or even members of the Armenian diaspora do to support the collection of evidence to ultimately receive justice?
I didn't understand what was the obstacle, so
I think using the evidence to make sure that the evidence gets used to some result.
if we have these testing results proving the use of prohibited ammunition, weapons, and so on, we can use this evidence while working with international governmental and non-governmental organizations to make inquiry and report independently on the issue. So we have international reporting confirming violations. And second, we are free to use this evidence during court proceeding as far as we have links between the subject matter of the case and evidence, but we don't have very strict rules in terms of collection of evidence. So not too much formalities about the party who gains the evidence. So if the evidence is there, it's credible, verifiable, you can provide it to the lawyers working on the cases or the government, and they can use during court proceedings.
I know we have a lot of questions, but I'm going to use the opportunity of the format of that question to just say one very, very small thing. As a diasporan Armenian who's lived and worked in Armenia back and forth for about 6 years, I just want to emphasize, because part of the question was, what can the diaspora do to help? What you can always do is ask, how can I help? There's a lot of facts on the ground that you don't know. The context, the local context is not your context in the diaspora. there's a lot going on that you don't understand or are not aware of, not to your own fault, of course. But diasporans need to first ask, how can I help, and can I? And what can I do that will not make it worse? So let's all help in that spirit.
Talin, the next question is for you. What would creating a claims commission for Artsakh entail? How can it be initiated?
So again, United Nations Security Council is one solution that I think we should put off the table. I think Russia's veto power in the UN Security Council would absolutely be used. So that's off the table. There is some options. Yeah, it would be bilateral, but also we could use a neutral third party. Like I would say probably the most likely one would be France, probably as a neutral third party to help with the negotiation. Again, as I said, the commission would have to be set up with a willingness of the parties to set it up. So, and then they would discuss what procedures they want, where the secretariat would be. For example, I think a good candidate would be the Permanent Court of Arbitration in The Hague. So the negotiation would start with Armenia and Azerbaijan, neutral third party, probably France. And then they would have to choose a place. I would suggest the Permanent Court of Arbitration. And then they'd have to choose, it would likely be something along the lines of Armenia chooses 3 arbitrators, Azerbaijan chooses 3 arbitrators, and then those 6 choose another 3 for a whole panel of 9. And then they can choose the nature of the claims that they will hear, and the deadline of the claims and all the other procedures. But that's the general outline.
And to be clear, that means that claims would be adjudicated on either side?
Yeah, claims would be adjudicated on either side. This is a claims commission is for both sides, for all victims of the conflict.
Thank you. We have a million more good questions. Guys, thank you so much for these great substantive questions. I want to thank the speakers. You did an excellent job. Thank you so much. And the next thing we would like to ask you to do is to please come with us to Manugyan Hall. Back across the hallway, we have a nice award to give, and we want you all to be there. Thank you.